Good morning, WTOB listeners. I'm Dylan Greenwood along with Harold Eustache, and we're here on For the Record with Greenwood Law. And on For the Record with Greenwood Law, we like to talk about your rights and talk about ways in which you can protect your rights, knowing your rights. And this past week marked an anniversary of the passage of the Americans with Disabilities Act. And I know that it frequently comes up in our practice about the rights of people who are disabled, but both physically and mentally, and also the rights of people who don't necessarily fully understand what's going on. And that can be in a lot of different ways. That can be juveniles who may not fully understand what's going on in the process. It can be people who don't speak English that maybe not understand what's going on in the process. And so what we're going to talk about today is just what rights these people have, what rights they have to understand what's going on, what rights they have to due process of the law and equal protection under the law that's afforded to us under the Constitution. And it's an important issue because, it is protecting those who may not always be able to protect themselves.
Right.
And it's incumbent upon, I feel, everyone in the criminal justice system or even the court system to look out and to be prepared to handle those issues. I know we've had them pop up. You and I both have had these pop up for different reasons of late. I know you had an issue with a traffic stop involving a deaf individual. I have a traffic stop involving somebody who does not speak English at all, and just what happens in those situations. And so I think we can use that as a jumping off point in talking about what rights people have, how this is viewed under law, when did the rights attach, and that sort of thing.
Yeah, well, so in my case, it was a person who is deaf, and obviously that is a person who's deaf or hearing impaired. That is obviously a disability, and it's covered by the ADA, the Americans with Disabilities Act. And I will tell you that at trial that was an issue as to whether or not this person, when they're giving statements to law enforcement on the scene and law enforcement is investigating a crime, are those statements understood, or is that person understanding what exactly is happening? And so a lot of those issues are addressed in statute, and some of them are addressed in the ADA itself. And there's some guidance from the Department of Justice on how law enforcement officers are supposed to interact. One of the main things, at least with deaf people, is that it can be an issue for law enforcement because a lot of times, of course, a law enforcement officer is walking up to a situation and they don't necessarily know that this person has a disability. And at first, that can be an issue where they think the person's trying to resist or evade or sort of get out of it. In this instance, the person, it was identified pretty quickly because there was another individual there that the person was deaf. And so the issue became, do they have to have a qualified interpreter on site? I mean, who can interpret for a person that's deaf, and how does that work? Well, the guidance from the ADA is that a person who is deaf, when interacting with law enforcement, should be able to choose the type of communication that suits them the best. So be that an interpreter, be that written communication or sign language or whatever, they can sort of make that choice and communicate how they want to be communicated to, that they understand. There is some law in North Carolina around this. There's a statute, and it's actually relevant in my case. It's under 8B-2 that says if a deaf person is arrested for an alleged violation of the criminal law, including any local ordinance, the arresting officer shall immediately procure a qualified interpreter from the appropriate court for any interrogation, warning, notification of rights, bail, or other preliminary proceeding. No statement or admission taken from a deaf person without a qualified interpreter present and functioning is admissible in court for any purpose. So here in the North Carolina legislature is recognizing the importance of these interpreters, of the rights of a person who is deaf, and this goes back to what Dylan said earlier about their due process, because it's important that a person understands what's going on, understands in these important parts of any proceeding, be it an arrest, be it an interrogation, any notification of rights, arraignment, that they understand what's happening. Because if they don't understand what's happening, there's a potential issue about whether they've been put on notice. And we actually do that in every kind of case. If you think about it, as I'm talking, I'm just thinking, even cases where people are fully competent, and we still make sure that they understand every bit of what we're saying.
Yeah, it's part of our obligation as attorneys. And what's interesting in the context of a DWI specifically is, after arrest and you're taken in, a lot of times you are given implied consent because of your privilege driving out on the road in North Carolina. It's implied consent that you're giving to provide a blood or breath sample or urine to determine blood alcohol content or whatever else may be in your system. That, because of that implied consent, it creates this weird conflict in the law with the statute that you're talking about. And it's not clear. It's not clear because North Carolina courts have not interpreted whether or not a deaf person needs to have an interpreter, whether it be sign language or whatever else, for the conveyance of their rights per the statute for whether or not, or when they're about to do an intoxilizer or breath machine or a blood sample. Now, a statute for a blood sample, a breath test after arrest, states that a person is supposed to be advised of their rights both verbally and in written form before that's given. What's interesting is that our North Carolina courts have said basically, okay, you can state them, it's fine, they just have to be advised, but you don't have to prove that someone understood them.
Right, and that's a very important
It's
caveat.
a really, really important distinction, and one that is so important for in these deaf cases involving deaf people, but also cases involving people who need interpreters. And so before we get there, I want to say that it is unclear because, a deaf person, obviously they can't hear. And so the spoken aspect of what is required, logically, you would think that it has to be conveyed via sign language, or in a way that the person can receive some sort of notification of it beyond the written form. Logic doesn't always dictate what we do in court, though. And that's the frustrating thing in all of it. And it's frustrating that we have this lack of clarity. Now, on one hand, I understand how the Court of Appeals comes to a conclusion that you don't have to provide proof of whether or not someone understood their rights before they did a blood or breath test after arrest. That just logically makes sense because I think it was looked at back in the 60s or 70s. Dude was so hammered drunk that he was like, yeah, I didn't understand anything. I couldn't have understood anything. And so if the whole point of the test is to figure out a level of intoxication, but then if you get to a point that you are so intoxicated that you can't bring in the evidence of the test itself, that brings up an interesting issue. But it does seem, on the other hand, why do you have a law that says you have to inform someone of their rights, both verbally and in written form, if there isn't some need of understanding?
Sure.
And that's where I'm having trouble sometimes with this. And that has become readily apparent in cases involving translators.
Right.
Where the North Carolina case that looked at this has a lot of interesting caveats to it. The person, when they were pulled over, never needed an interpreter, was able to do all the field sobriety tests without an interpreter, never asked for one up front. And then all of a sudden, when that person gets to the station and is about to do the breath test, all of a sudden they need an interpreter. So if you read kind of the subtext of the case, there's an inherent skepticism. And I think that skepticism helped sway a decision a certain way, because, how do you know whether someone's being legitimate about whether or not they really understand? And I think it brings up all these different questions, and it's kind of this classic example of, well, we're trying to do our best in the law and how this should all work. And so it is an interesting thing, because the whole aspect of whether or not an interpreter is needed specifically for these DWI related issues isn't clear. It isn't quite hammered out in the same way it isn't hammered out for someone who's deaf.
No, that's true. And I know in that case that you're referring to is interesting. I think that does come up sometimes in court, where if a person, it does matter when, sort of on the timeline of events of some sort of issue, when a person needs an interpreter, and that the court does view that differently, based on if they need an interpreter in court that day all of a sudden, or if they need an interpreter at some other point when they're pre or post arrest. Courts do take that into consideration. I think one of the issues that you had was a person that needed the interpreter the entire time, and whether or not they understood those implied consent rights. And I think, as you said, we don't know if they did or not.
Right. And you and I both sat on a DWI together where we watched the video, and there was an obvious lack of understanding during the field sobriety test level. Our client kept saying in another language that she couldn't understand, and the law enforcement officer in the case kept barreling forward and basically trying to convey that, hey, this is what you need to do in this test. Look, basically pantomiming what needed to be done, which is not allowed under the standards for the field sobriety tests. And at trial, I remember very distinctly, she needed an interpreter there to understand what was going on in the trial. And the judge is looking at this going, well, she's sitting here with an interpreter. How basically looking at the state saying, well, how do you expect to say that this is valid evidence of anything if she didn't understand what was going on? And I know we were sitting there going, yeah, exactly. That's part of our big point in this whole case.
No, it is an interesting oxymoron in a sense, because we do we do everything we can to make sure that people understand, and this is the entire, when I say we, I mean the entire system, that people understand what's happening in court, that a defendant especially understands what's happening in court. That's why we do plea transcripts and stuff like that. And so to say that, and it's important that they understand, and we'll even ask, do you understand what you're getting into? Do you understand what's been read to you? So it's interesting that we make sure the defendants understand, except for some parts that could be used against them later, sort of post-arrest stuff that could be used against them later. And that's an interesting sort of...
It's weird when it attaches.
Right.
It's like we're willing to set the trap, but once the trap's been set, now it's important that you understand. It's important now that you understand how, just what penalty you're going to get from this.
Right. And I think that's what we're saying here, is that somebody could make a statement against themselves, not understanding exactly what's happening, and then that be used against them. So to that point, that's why there are all these different groups about, rights for the disabled, rights for people who, can't understand English fully or whatever else. And every single one of them recommends that the soonest point, the quickest point in your interaction with a law enforcement officer, you make it apparent what is going on with you. Make it, apparent, I don't speak the language. Make it apparent I am deaf. Make it apparent that
I have, I don't have a leg from the knee down, whatever it may be, because, that one's an important one, because if an officer asks you to step out of the car and you need a cane, you need some sort of assistance, and you're reaching over and it's dark and the officer can't see what's going on and they think you're reaching for a weapon, then all of a sudden not to put the onus on the person who was pulled over, because law enforcement officer definitely needs to make sure of stuff before they take action, but that's a nervous interaction to begin with.
Mm-hmm.
And then you've potentially made a motion to make a nervous person even more nervous. And so that's why every single one of the guides and everything out there say, hey, let this person know ahead of time. Say, listen, I've got a physical disability. If you want me to get out of the car, I need this cane. My cane is over here. Let me reach for it and grab it. And you know what? At the end of the day, that type of communication is always something we condone with law enforcement officers.
Absolutely.
Time and time again on our program, we say, hey, don't talk to law enforcement officers about stuff. Well, that's about the substantive aspect. You get pulled over, how fast were you going? Well, you answer that question, you probably are admitting a lot of stuff. What were you doing earlier today? How many beers have you had to drink tonight? You're admitting to stuff. But you talking to an officer saying, hey, this is going on with me. For me to be able to address you or work with you right now, I need this item, or I need you to know this about me. I would like an interpreter because I don't understand what you're saying. All that stuff will just help you out. I don't think most law enforcement officers out there are going to feel a certain type of way about that. I think they would rather have a positive interaction with you than not.
Oh yeah, absolutely. If you're just joining us on For the Record with Greenwood Law, I'm Harold Eustache along with Dylan Greenwood, and today we're talking about issues with the rights that you have if you're disabled. So issues with interpreters and those sorts of rights. It's important to know those rights if you are. And I know sometimes you may think, well, I'm not disabled. I have all my limbs and that sort of stuff. But there are other ways that you can bring up issues with disability that you may not be thinking about. And it sort of goes back to what Dylan was talking about earlier about, if you have something and you have an issue, it's important to bring that up with law enforcement. We were talking about physical issues, but there could also be mental issues. So, for example, if you have multiple sclerosis, MS, or you have issues with PTSD, MS is a physical issue too, but if you have even mental issues that could present as impairment. So a lot of times when an officer is looking at you and trying to understand whether or not you qualify as impaired, they are looking at your both physical and mental faculties to determine impairment. And if you let an officer know, well, I've got a mental issue already, that is important because it can negate potentially any of those mental faculties that an officer is saying, well, that goes to impairment, but this person has already told me they have a mental issue. So it may sort of negate some of that probable cause that an officer may be building with regard to impairment. So it's just important to know that you have those issues, to present them to an officer if you do have those issues. And those mental impairments, you may think they're not important, but they can be really, really important in court, and they can even go to determine whether or not you're competent enough to stand trial, and that's a whole kind of another issue there too.
Yeah, you've got a case where there's a medical issue that you wouldn't necessarily think about it, but it presents like someone's impaired.
No, it really is. It's an important medical issue that this person has. And my client said, "Look, I have this medical issue," and she went to the doctor that day and spoke with her doctor, and lo and behold, her doctor was going to testify as an expert witness and said this presents as impairment, and sort of shows all these signs. Is going to explain how that works medically. So it's important to talk about those things, to let law enforcement know, to let your attorney know if you get to that stage, and make it an important issue, because people won't know if you don't bring it up.
I think it's important to also draw a line between what is a true issue that you deal with versus what you may take for the issue, because you still can very much get charged with something, including DWI, for taking prescription medication. And there are plenty of prescription medications out and about that impair your faculties. Just because you take that with a valid prescription does not mean that you are absolved from criminal liability, whether it be driving while impaired or whatever else. So you admitting to what you are taking could be huge evidence against you.
I'm so glad you said that's one of the most important things we deal with all the time. So, people will say, well, I told the officer, I was taking Adderall and that's all, and there, unfortunately that could be used
it's an
as
amphetamine,
right? It's evidence against you of impairment. And so even if it's prescribed, and I know, it's very important to note that, you showing up to court with your prescription bottle is not only not a defense, it may be used against you because the prescription doesn't matter. Just think of it this way, a lot of these medicines you take they have labels that say, don't operate machinery or don't drive. If it's one of those, it might be smart not to do those things, operate machinery, drive if you've been using that or taking that medication. So think of it that way.
Right. These are just some of the potential issues that can come up, or the rights that people have with any type of disability. Some other ones that I can think of off the top of my head are rights of these individuals at the jail or prison. Mm-hmm. So a lot of times, so like let's say you take medicine for just a regular, let's say you take like a baby aspirin each day. More likely than not, you're not just going to be able to get that stuff at the jail. But let's say you have like a chronic thing, like you've got diabetes, you've got like an epilepsy type condition or something like that is, I know every issue is serious to the person dealing with it, but I think these type of chronic big type of issues that a jail or a prison wouldn't necessarily be equipped to handle if some sort of emergency arose. I can tell you right now that facility is going to want to make sure that you have your medication. And actually there are rules in place that they are not supposed to get in the way of you getting that medication. Now they might help you administer it, like if you're insulin dependent for diabetes, they might be the one to administer your insulin because they're not going to give you a sharp object in a confined population like that. But you have the right to be able to have access to those types of things. And if a facility or if you know of a loved one where they're getting denied access to that, there are avenues to call the Attorney General's office and to call Department of Corrections, to call the individual facility, like if it's a county facility. Most county jails are run by the sheriff's office of that county. Right. Call the sheriff. Let them know that, hey, this is happening. This person needs this stuff. And if you can't figure that out, or if you can't get a hold of somebody, contact that person's attorney. They might know somebody to contact, or they might get a call back quicker than you can. And that's a really important thing, because just because someone is in jail or prison, and because you're incarcerated, doesn't mean you shouldn't be able to have access to those types of things, because then you're getting into Eighth Amendment territory where it's potentially cruel and unusual, because you have so severely hampered someone's quality of life. And the ADA, or the Americans with Disabilities Act, is something that is supposed to ensure that for everyone. Other things I can think of, and this may seem very obvious, is your ability to access court. So think of all the old school courthouses in North Carolina that had to change with the ADA, where they were only accessible by, the stereotypical huge flight of stairs. Think about that classic scene of when you're coming out of court and it's always on the big marble steps, and, justice has been served, or, I can't believe what happened in court there, or whatever. It's the classic scene. But if you're wheelchair bound, if you have an amputation or whatever else, and you need a key, that can be a prohibition to you being able to get an access court. Court is supposed to be accessible to everyone. And my biggest recommendation for people, if that is an issue, whether it is loss of hearing, loss of sight, some sort of physical thing, a mental thing, there are resources for the administrative offices of the courts for you to make requests for different types of concessions and accommodations for your ability to access court and to have your day in court. If you have an attorney, it is a great idea to let that attorney know so that that attorney can apply for access to these types of accommodations. We've done that in plenty of cases. And there's all kinds of resources available for that to happen. In that case that you had with the DWI with the deaf person, there was a translator that came down that did sign language for the whole hearing.
Right.
That is available here in North Carolina per the statute.
Thank you for joining us on another episode of For the Record with Greenwood Law. I'm Harold Eustache with Dylan Greenwood. We hope that you got something out of this discussion today as we talked about your rights to interpreters, your rights if you are if a person is disabled under the Americans with Disabilities Act. And next week we're going to be talking about another interesting topic, so we hope you join us next week. But before we go, Dylan?
Yeah, first and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. That's that Greenwood Law Bill of Rights. Remember it. It's not a crime to know your rights. Stay safe out there. This is For the Record with Greenwood Law, signing off.